FAA import approval, registration, deregistration, airworthiness, noise, and emissions. Hello again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to the second segment of the analysis, the second layer, because this is where sophisticated parties often discover that customs clearance does not finish the job. On the FAA side, the import analysis begins with a basic rule in 14 C.F.R. section 47.3. An aircraft may be registered in the United States only when it is not registered under the laws of a foreign country and otherwise qualifies for U.S. registration. That may sound obvious, but it is one of the most operationally important sentences in the whole process. A foreign registered aircraft does not become registerable in the United States because the buyer expects it to. It becomes registerable when the foreign registration issue has actually been resolved. Section 47.37 deals directly with an aircraft last previously registered in a foreign country. The owner must submit satisfactory evidence of ownership and satisfactory evidence that the foreign registration has ended or become invalid. The FAA's own import registration instructions may say the same thing in practical terms. The applicant needs a statement from the foreign registry showing that the prior registration has ended or that the aircraft was never registered there, along with evidence of ownership and the FAA registration application. That issue is not theoretical. In IAL Aircraft Holding, Inc. versus FAA, the 11th Circuit dealt with an aircraft that had been sold for U.S. registration but remained tied up in the Brazilian registry. This case is a vivid reminder that deregistration friction abroad can derail what looks like a completed transaction on paper. The public record in that matter is useful because it shows just how long and expensive registry problems can become when parties assume the foreign side will sort itself out. Then there's the airworthiness side. FAA import airworthiness approval guidance says the importer should receive an export airworthiness approval or equivalent certifying statement from the Civil Aviation Authority of the country of manufacture, and the United States must have a bilateral agreement with that country. For a standard airworthiness certificate on an import aircraft, 14 CFR section 21.183C requires that aircraft be type certificated under sections 21.21 or 21.29. That the state of manufacturer certify conformity to type design and condition for safe operation under the applicable agreement, and that the FAA itself find conformity and safe condition. For used aircraft, the process gets more textured. Section 21.183 requires evidence of conformity to an approved type, design, and applicable airworthiness directive, plus an applicable inspection, and an FAA finding the aircraft conforms to type design and is in a condition for safe operation. In other words, importing a used aircraft is not merely a paperwork exercise. It is an exercise in conformity. And there is another point many business people miss. The FAA import rules are not limited to basic airworthiness. Section 21.29 ties import procedures to Part 34 emissions and Part 36 noise as the applicable environmental requirements. Section 21.183 also expressly incorporates noise compliance for import airplanes and bars original issuance of a standard airworthiness certificate where the applicable emissions requirements are not met. So, an import analysis that ignores noise, emissions, and related configuration status is incomplete. Here is something to take away from this. And remember, Customs can get the aircraft through the border, but only the FAA can get it into a legal operating system. That is why records matter so much. Maintenance status, AD compliance, equipment approvals, modification pedigree, prior registration, and even seemingly small discrepancies in export documentation can slow or compromise the import. A buyer that says, "We will fix the records after closing," is often saying, "We will inherit the seller's import problems after the money is moved." So the right import strategy on the FAA side is disciplined and sequential. First, confirm eligibility for U.S. registration. Second, confirm foreign deregistration or legally sufficient evidence that it has ended or become invalid. Third, confirm the type certification pathway and bilateral framework. Fourth, confirm conformity, AD status, inspection path, especially for used aircraft. Fifth, confirm the noise, emissions, and related certification overlays before the aircraft is repositioned. In short, the FAA side of an aircraft import is not a clerical afterthought. It is where border entry becomes lawful U.S. operation. Take this away. An import aircraft is not truly imported when it crosses the border. It's truly imported when its registry status, airworthiness status, and operating status all align. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Please discuss the facts of your matter with qualified aviation, customs, tax, and regulatory counsel before acting. We appreciate your interest and questions are welcome. You can direct questions to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.